We're back. And now it's for me to talk about my topic, which is electronic discovery in healthcare litigation. Let's jump in here. Oopsie. Okay. This is a sort of a roadmap of what I'm going to talk about, problems and solutions in electronic discovery in healthcare litigation, ESI management and discovery, best practices, audit trail discovery. If you don't know what that refers to, you're about to just buckle up. You're about to learn. And I'm going to talk a little bit about ESI discovery asymmetries, and I'll explain what that means when we get there. This all, most of this is pretty heavily focused on discovery and electronic discovery in particular in medical malpractice litigation, which, as I mentioned at the outset, is a big chunk of what I do. And beyond that, it's going to be most relevant, I think, to healthcare providers and healthcare systems and so forth. Again, I hope there's some nuggets in here of interest to everyone who's tuned in with us today. Really, what I want to talk about is going to spring from my practical experience. I've been doing this for nigh on 15 years now, longer than my web bio photo might suggest. And I have done a lot of medical malpractice litigation over the years, along with really kind of the full range of, I guess, what we dorkily call complex commercial litigation, ranging from securities and financial services litigation, antitrust, all manner of things that more traditionally sweep in what I think of as kind of the most sophisticated versions of electronic discovery that many of you are probably familiar with if you've worked in commercial litigation. And so what follows is going to be mostly a lot of practical thoughts and tips that I draw from my experience. Fair warning, there might be some editorializing in here, and hopefully you'll forgive me that. But the basic idea here is that over my career, I've seen that the technology, the data systems, the potential for discovery in medical malpractice in particular has evolved massively in the last decade to 2 decades. If you work in this area, you surely already know that. And my experience has actually been that the sophistication and the practices and the ways that medical malpractice lawyers come at these cases severely lags the technology. And that's often true in the law. We all have seen how the law almost always lags technical development. I find it to be particularly true in medical malpractice. And I think there are some reasons for it, and maybe the reasons don't matter, but worth just saying out loud. I mean, I think there's a structural reason fundamentally, which is number one, a lot of med mal defense lawyers exclusively do med mal. And there are reasons for that. By definition, it is a repeat business in the sense that law of large numbers tells us that any healthcare provider or health system is going to get sued repeatedly. If they continue to care for patients, they're going to get sued, hands down. And so it becomes, it lends itself to a form of sort of, if you will, form litigation. And in addition to that, many medical malpractice defense lawyers sort of primarily work for or on the panel of professional liability insurance carriers. And there's a set of incentives that comes along with that, including cost limitations and so forth, that in my experience and opinion can lead to less than the greatest approach to how to manage these cases. And so I think there's a lot of value in bringing a perspective to these cases that is informed by a broader set of experiences in litigation, as well as some technical sophistication about electronic discovery and how both to handle the technical aspects of these things as well as the legal doctrine. As I said, I mean, med mal litigation can lend itself to sort of autopilot. We often use the same kind of form discovery requests. We get the same form discovery responses. People often sort of myopically assume that the only relevant discovery is going to be the medical record and then the opinion of some learned expert. And I think the reality is things have evolved in a way that worldview is no longer very healthy. There is in the Zen Buddhist literature, there is a concept called beginner's mind, which you may be familiar with, but the basic notion being that you should come at the world at every moment with the mind of somebody who's utterly uninformed about any of it, with a curiosity that brings a sort of fresh perspective. And that's what I try to bring to these cases, as a sort of beginner's mind. And that, I think, is what will influence what you're about to hear. So let's jump into it. Here's the roadmap. So let's start with problems, right? Some of this, again, I'm Captain Obvious. For those of you who work in-house for healthcare systems, you know some of this, and some of this is repeating what I've just said. But we've seen over the past decade plus an incredible proliferation in the actual computer systems that are used to deliver healthcare, in addition to a proliferation of regulations that seek to influence what those systems are and how they function, both at the federal and the state level. That makes things far more complicated than, back in the day, when the discovery in one of these cases would be like literally the patient's physical paper chart with illegible physician chicken scratches in it. Obviously, healthcare systems need, setting aside litigation, you just need to be compliant with the regulations and so forth. You need to be consistent. You need to have reliable functional systems. That means they work, they are technically effective, they are compliant. But you also need, at least from my perspective, to be thinking about litigation risk prospectively when you think about how to set up and manage these systems. I hasten to add, I am not really a compliance guy, and I can point you to those folks. We've got them right here at Dorsey. So some of that is some of the sort of background regulatory stuff influences what I'm going to tell you about, but I'm not the expert in that area. But I know where to find one if you need one. And finally, legal doctrine and practice, as I said, I think lags the technical evolution that we've seen in the industry, and so I'm here to try to push that forward just a little bit. I did this. I was doing this on the airplane actually a few days ago as I was getting ready for the talk, and I just thought to myself, like, can I come up with? I was thinking about the archetypal case of just like, here's the patient's record and that's the case, right? And I thought about what's like the totality of different sources of potentially discoverable data that might come up in a contemporary medical malpractice case. And this is the list I came up with in maybe 90 seconds. I'm sure it's probably a third of as long as it could be. But you've got now, obviously, the electronic medical record, which, if there's any provider out there that doesn't have an electronic medical record, I'd be a little surprised. You have often within the medical record, I have come to learn, there may be messaging systems that are embedded within that software, such as like instant messaging. There's separate paging systems sometimes. There may be separate messaging systems that some healthcare entities use. You have radiology data imaging software or other technical diagnostic devices. Different kinds of medical devices may have all manner of storage and tracking of different kinds of physiologic data and so forth. EKGs, you can run the list, and each of those different systems and devices might have literally its own software, its own database. Some of those might be administered by a third-party vendor and not even not the entity that we are representing. You can have separate scheduling software. Sometimes plaintiffs want to know about people's schedules. You can have what I mean by provider analysis and presentations is what I was alluding to earlier. At least some significant subset of my cases, I learned partway through the discovery process that somebody created a PowerPoint to present at an M&M conference or some kind of peer review thing, and suddenly that's, at least it is in theory potentially discoverable, probably peer review, as we've just discussed. But you learn about that. Where is that located? On some shared drive somewhere. Provider emails we've already begun to talk about. Back in the day, and when I say back in the day, I mean early in my career, I don't think we really even thought about it, because we were like, why would providers be emailing each other? They shouldn't. Well, they do constantly, constantly. And they text each other constantly, or their patients a lot. And those are discoverable, or they at least need to be looked at, right? And so you may have personal devices, you may have text messages, you could have social media. I sure hope your providers aren't putting stuff on social media that would be relevant to patient care, and I'm sure they all know better. But social media is out there. We all know about that, and there's plenty of CLEs about discovery on social media. So this is just by way of table setting, to sort of reinforce the scope of what I see as the problem and the issues that I want to try to talk about. How do we deal with this, right? So a few solutions. And most of this is really kind of just generic, if you will, best practices that you'll find in a lot of CLEs and resources about ESI management. But I'm really here trying to reinforce how important I think it is for healthcare providers and systems, who I think often have been a little behind the curve on this front. So effective management of the ESI, anticipation of litigation risk, and standardized processes. What I mean about that is, number one, management means skip to best practices to just put some flesh on the bones here. Understanding the systems that you have. So like if you're an in-house lawyer at a health system, do you know like where all these different data sources are? Or does somebody, or like, do you know the person who does know, or the document where this is listed? It hopefully exists somewhere. And if it doesn't, it's worth beginning to map that stuff out. Relatedly, understanding and documenting effective data retention and deletion policies. If you've been to a CLE before, you've heard this stuff. So this is really a reminder and not intended to be super detailed, but it is best practice, of course, to have some documentation or at least awareness of what the different data sources are, how they are retained, how they are stored, when and how they might be deleted or purged from a system can become relevant, as everyone knows, in discovery. And that stuff can obviously matter if somebody learns after a claim comes in that something was deleted or something was lost or we don't know where to find it and so forth. Best to think about that stuff ahead of time. Clear policies and provider training on systems use. By this I have in mind, and again, alluding back to my comments about provider emails, do the doctors know if they're supposed to be emailing or not? Sometimes we see in cases, for example, this is very common, that, for example, physicians or different provider groups might have a standard process where they email each other about, like, when they go off shift, they email a summary of things that are happening. That's fine, that's normal, and that seems like that's a standard practice that they have, and I don't see any problem with that. On the other hand, if they're just randomly sending a one-off email, why are they doing that? And should they be? And is it consistent with your policy? I'm not here to say that one way or the other is the only right way to do it, only that some thought should be put into it so that people are behaving in a way that is consistent. And obviously, when it comes to personal devices, you've got to have some clarity about whether providers should be using those and how they can become subject to discovery if somebody uses them, whether or not it's consistent with policy. You've got to have a policy on legal hold notices and a process, most importantly. And finally, relatedly, a standard process to collect ESI in anticipation of claims and litigation. I pause here because it occurs to me I should probably define ESI. I think probably everybody knows what that is, but ESI means electronically stored information, and is sort of the corny, like 2003 era term of art that I think the federal rules and other courts use to refer to data, to electronic discovery. Yeah, please.
Definition.
Yeah.
In anticipation of claims and litigation.
Yeah.
Like, when does that happen? Does that happen when someone dies in a hospital? Does that happen when surgery doesn't go as expected? Does that happen once a risk manager has reviewed it and flagged it?
Yeah.
For legal, there's sort of seems like it should be obvious, but it also seems like there could be a whole continuum of when that actually occurs.
Yeah, I think you're right. So the question for the web folks is, when would a court or when would we conclude that somebody has done something in anticipation of a claim in litigation? And the questioner astutely points out that it may be a continuum. I think that's right. Thank you for the question. I should have researched it so I had a really crisp answer, but I'm not afraid to go out on a limb here. I think the answer is going to be that it's a fact-specific inquiry that sort of depends on the circumstances, and that's what a court is going to look at. I think you're exactly right that it's going to be on a spectrum. So a lot of organizations might have, for example, like risk management might just audit different files like on a standard basis, whether or not there's any indication of a claim. And that, I presume, would be sort of not an indication they're anticipating a claim because they just do it automatically. On the other hand, if there's a showing that, for example, there was an adverse outcome for a patient and a bunch of risk management people ran to the scene and started looking at stuff, I think that's going to begin to make a court think that they're anticipating a claim. And then quite obviously, when there's actual notice of a claim, that's a clear cutoff point. And it's somewhere before that clear cutoff point and toward the earlier in the process where things get grayer. I don't think, and nor would I advise that you need to be sending out a litigation hold like every time there's an adverse outcome for a patient. That'd be crazy and unworkable and problematic for a lot of reasons. And I can't imagine a court would think that. But I think it's going to depend on, for example, what is communicated by the patient, by the patient's representatives, and so on. And, you know, somebody just going and looking at a record because of an adverse outcome can be explained in all manner of ways, not least of which is peer review. We wanted to improve care and find out what happened here and look into it. So the answer is there's probably not a clear answer. It's going to be context specific.
But I do
please.
think if patients or patients' family or other representatives are raising a lot of questions or anything to the providers just doesn't feel like it's going well.
Yeah.
I think that would be a great place to educate providers. If that's happening, you should probably escalate that to somebody else. And they should know, right, when this isn't a standard conversation with the patient or their family. Like it feels adversarial or there's potential for trouble. That's probably a good indication for providers on when to raise that question to legal or someone else.
Yeah, and then the issue becomes sort of legal may get wind of it, and the question becomes, when do you start taking action? When do you issue a legal hold notice? And that's something, you know, again, I think it's going to be context specific, and you've got to be sensitive to your business and patient care imperatives, and you can't just jump all over everybody immediately the moment something starts to feel potentially adversarial. I think it becomes a judgment call most of the time. The standard process point I just want to emphasize, which is, again, this is just practical experience on my part. Very, very often in medical cases, healthcare systems tend to have a kind of standard way that they go about collecting. It's like the medical record, obviously, is like the first thing that we tend to get. It's like, here's the medical record, great. Don't stop there. Like, what I really want to encourage our clients and providers to think about here is think about creating a standard process for every claim and case where you are at least going through a checklist to ask yourself, are there emails? You know, who are the key providers, and are there emails? Are there text messages? Is there other data that we should collect? I'm not saying it has to be leave no stone unturned the moment that a claim happens, but I am saying if all you think about is the medical record, you're missing something. And all of us will do better if we think more aggressively and proactively about how to gather this stuff up front so that we don't run into surprises as litigation proceeds. So that's really just like, honestly, very quick best practices. This is not, there are people that will teach like all day CLEs on electronic discovery, and I commend those to you if you have the patience, but this is really just kind of applying those general principles in this area in particular, where I feel that in my experience, they have not always been fully fleshed out. I'm going to talk now for quite a while about audit trails. What's an audit trail, you ask? If you don't know, I'm here to teach you. An audit trail is basically metadata that is attached to, or metadata about, an electronic medical record that provides a variable data set, and I emphasize variable for reasons I will explain momentarily, about access to the medical record by various people. So this is it can be a very large data set that might show that Dr. Iverson opened up patient Andrew's medical record on January 4th, 1999, and he took certain actions within the medical record. It might be that he viewed certain things. It might be that he made a note. It might be a million different things. Maybe he made an order. All the lawyers who work in-house at healthcare systems are rolling their eyes because they know this, but for those who don't, that's basically what an audit trail is. I want to talk a little bit about the legal, and the reason I'm raising this is it's sort of a case study of what I think has evolved in electronic discovery in medical litigation, because it's a hot topic in my world. more and more and more of my med mal cases, probably more than half by now, involve some kind of dispute over discovery into the audit trail. And as some of my clients have heard me say, I swear the plaintiff's bar is having CLEs of their own, where there's like an hour-long presentation and some guy's just telling them, demand the audit trail, demand it loudly. And so we're responding to that. And we're seeing more of these requests and we're having more fights about it. So that's what I'm here to talk about. So let me give you a little bit of the legal background, because this really is going to matter for the litigation part that I care about. Again, not really here to give you compliance advice. Special thanks to my partner and personal hero, Ross Emanuele, who knows this stuff cold, and he provided me some guidance on this. But the audit trail actually arises from HIPAA and high tech, which is a subsequent statute and set of regs that has to do with primarily privacy. It was sort of the driving force behind this stuff. And the audit trail, the reason I'm talking about this is because plaintiffs' lawyers always tell me, I know that your client has an audit trail because federal law mandates it. And I know everything that it should say because the feds mandate it. So actually, not so exactly. It's a little more complicated than that. The audit trail comes up through HIPAA's security rule, which sets forth a bunch of security requirements, again, to safeguard privacy in medical records. And what it basically says is, and I've excerpted the regs here, but you've got to have access controls. And then the subpart B here talks about audit controls. And all this really says is that providers need to implement hardware, software, and/or procedural mechanisms that record and examine activity in information systems that contain or use electronic PHI. The regulatory advice that I'll convey from Ross is providers should periodically review their systems to make sure that they are compliant and are executing on this. The point I'm emphasizing here is that that's actually all the regs really say about what's required of providers. Now, it gets thornier. The Office of National Coordinator Health IT Certification Program is a regulatory overlay. The Office of National Coordinator basically oversees a program to certify health IT. And the punchline here is, as you see in the second paragraph, this is a voluntary certification program, and it applies to third-party vendors who create and market health IT and electronic medical record systems. So is this part of federal law and the federal government? Yes. Is it a federal mandate that binds providers to execute on the security rule in a specific way? No. There are good reasons why providers and the vendors who sell them technology should want to comply with and be certified, but it's not the same thing as saying, if you don't have this particular form of audit log, you're violating federal law. What is the actual regs that come up under the Office of National Coordinator Program? And this is why I'm raising this to come back to the point. I have had many a debate with plaintiffs' lawyers in which they tell me, your client has not produced a complete audit log, and I know it because a complete audit log would have the following 96 data fields, and it would tell me this, that, and the other thing. And I know it because the federal regs require it. This is the actual reg in front of you. And what it says is audit log content. I didn't excerpt that part of it. ASTM E2147-18. What on earth is that? ASTM is an international standards organization. It's like a private entity that sets forth standards for, like, how big should a light bulb be and stuff like that. I think it's one of these organizations that had a really broad range of different standards that they set. And the federal regs incorporate this standard, and it's got a bunch of language in it. You have to go and buy it. I didn't buy it. Like, it's way more detailed than anybody cares about. The point here is the regs point to this big set of standards about what an audit trail probably should contain if it's going to be certified, but none of that is a mandate. And none of that really answers the question of what should any particular provider's trail incorporate. So that is a point I just want to pause on for the moment and draw that conclusion out, which is there are all manner of reasons why these things may vary among different entities, and reasons why those of us on the defense side, at least, need to be aware that when you're being told it must have X, Y, and Z in it, it's not so clear. I have seen, by the way, at least one case in which a court looked at this incorporation by reference of this ASTM standard and basically said, well, that's all federal law by reference. And I don't think that's the right analysis, but it's out there. So watch out. Another issue to think about in relation to audit trails is statutory rights, right? So I have seen patients or their lawyers demand a full copy of the patient's audit trail because it's my medical record. I have a right to get it, right? Not so fast. The Minnesota focusing on Minnesota here, not surprisingly, the Minnesota Health Records Act does give patients a right to request copies of their health records. Subdivision 5 is kind of the operative language here. I didn't include here because it would tire the eye, the very long definition of health records in the statute. I will tell you that it is very broad, and it is written so broadly that in my eye, it's absurd, to the point that it's basically like literally any information or data that relates in any way to the patient's care. Well, that might include the doctor's text to their spouse that morning saying, I gotta go do a surgery today. I mean, right? So it can't be interpreted literally in my view. And so it's got to be interpreted in a way that is sensible. And I think subdivision 5 gives you a sense that what the legislature intends here is kind of a common sense definition, which would be information related to patient care, including lab reports, x-rays, prescriptions, and so forth. And an audit trail, which is really metadata it's data about data, just really isn't part of this. There's no reason to think the legislature intended it to be. And I would not, and I have opposed requests for this under this statute on that exact ground to say this does not require a healthcare provider to turn over a full audit trail upon request. I'm not aware of any court decision addressing this issue. So it may, it's arguably undecided. Maybe one of these days it'll be pressed and decided. But again, the takeaway for now is I don't think patients have an absolute right to get this, at least in Minnesota. And now I'm going to show you a case in another state, in fact, where the conclusion was different under a different state statute. So let me pivot then to some theories and some issues that come up in litigation over discovery into audit trails. And the first, I'm sort of coming back to something I touched on already, which is scope and content. This has tended to be the biggest sort of fighting issue that I've had in a number of my cases where a plaintiff is seeking audit trail data. Very often my clients, and I think rightly so, are willing to discuss providing some of this data in discovery. Very often, and rightly so, I think most of my clients are not keen to provide all of it in some unlimited way, but it's more of a tailoring it to the issues. And I'll talk more about that. But one of the first issues that often comes up is, as I said, plaintiffs' lawyers tend to say, you're missing stuff. You're missing data here. And like a good boy, I go back to the client and go, oh, this guy says we're missing data. What do you think? And the client's like, no, this is all of it. And then the plaintiff's lawyer tells me, no, federal law requires that you have the following data fields, and it should show me everything that the doctor thought and said and did, every change they made in the medical record, every study they looked at, every message they sent. It doesn't, and it doesn't need to. As I said already, and when you look at the regulations, they do not dictate exactly what the audit trail must contain, point one. Point two, different healthcare organizations, like other large organizations that buy software or license software on a large scale, frequently customize it, sometimes very extensively. And so you will have different, those who work in this area probably are very familiar with Epic, which is the market leader in electronic medical records. And I have had many conversations with plaintiffs' lawyers where they say, I know how Epic works. I know how an Epic audit trail works, and you're missing the following. And by the way, I have an expert who will say that. And my guy says blah, 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 blah. Number one, just because it's Epic doesn't mean it's the same version at every different system. As I said, the law doesn't dictate what it must contain. I got to say, this notion of audit trail experts strikes me as a complete scam. God bless whoever these folks are for siphoning money away from the plaintiff's bar. But I've gotten to the point where I've had at least one matter where there was some kind of a written statement from one of these quote unquote experts, and like it's somebody who got fired from Epic or something 6 years ago, and they're like, I know everything about Epic, and some plaintiff's lawyer will pay them a few $100s to make stuff up about it. I've never seen one of these people have convincing foundation to talk about any of this. And so my apologies to any plaintiff's lawyers who are on the call here with us, but I suggest you stop paying these people because I'm not persuaded. It just becomes a nothing burger, frankly. We have these debates and then we end up basically saying, here's the data we have. That's it. That's how our system works. Your person can jump up and down all they want and wish it worked differently, but the courts always say, I can't make people produce what they don't have. And I've never seen it go beyond that. So that is an issue about scope and what should be in there. I would add as well, and it's purely just like a practical observation, I can't remember a case in which the audit trail actually provided meaningfully probative information about anything. In the CLEs that I imagine people are having about this, they're like, it's the Rosetta Stone. You're gonna unlock the case when you get the audit trail, and it's going to show the doctor did such and such, and they, that's going to unlock the case. I've never seen that happen. Very often they are utterly inscrutable. It's like a massive report of a bunch of gobbledygook data that sometimes it's just automated computer systems running through different things. It's often meaningless. Often we end up producing some version of it, and often it then goes straight in the garbage because it doesn't mean anything. But you got to have these fights anyway in discovery. So let me run through a couple of discovery. Now we've sort of laid the groundwork for what these things are and what they mean. I'll run through a couple of cases that have addressed some of what I think are the guiding kind of principles governing discovery of audit trails. The thesis here, the punchline for me is there's really nothing that special about these audit trails, right? Again, in my experience, the plaintiff's bar is really stoked about them in healthcare litigation because it's like something new. It's like a new shiny object. And it's a level of data that they're not accustomed to or that the industry hasn't been accustomed to for quite a while. But what I see in the cases I'm going to review with you are basically just courts applying off-the-rack doctrine to this particular kind of metadata. There's a universe of doctrine about discovery of ESI and metadata. You can just apply those principles here, and usually that's how things come out. Spoiler alert, it's often pretty fact-intensive. And you just got to sort of do the math to come up with the right outcome. I have not, by the way, seen any published decision in the state of Minnesota that addresses any detail about audit log discovery. If anybody knows of one that I missed, I would love to hear from you. But more broadly nationwide, there's not a ton of case law on this stuff. So what we end up, very often these debates happen short of formal motion practice, and they kind of get worked out usually. There's not a lot of case law is the point. So I'm drawing on case law from all over the country, but fundamentally the principles are pretty similar. So let's start with first principles. Relevance and proportionality really, I think, is what guides how I approach discovery of these things, which is, okay, Mr. Plaintiff, if you can explain why this very large volume of metadata is relevant to the actual claims in the case, we'll talk about it. And if not, we're not doing it. And that's basically what the courts say too. So I've given you this Estes case, and this is a case where the plaintiff was treated for 20 years and demanded all audit log data. And the court said, plaintiff has failed to articulate how an audit trail spanning 20 years, if such a thing even exists, is relevant and proportional to the needs of the case. Moreover, it's not apparent how any healthcare worker's access to plaintiff's medical record other than defendant physicians is relevant. Indeed, it is the defendant physician's alleged failure to adequately supervise, which lays the foundation for the action. And so the court says, you don't get it all. You can maybe get something that's tailored to the actual issues in the case. On the other hand, here's the Gilbert case that comes out in a different way, and it's because the facts are different. So this is a case where the plaintiff is basically, the theory of this case had to do with an emergency room doctor's alleged failure to supervise or really failure to pay attention to the patient in the emergency room. And you can see it from the quote from the court here. The plaintiff was able to articulate that and explain, in this context, it actually becomes pretty relevant to be able to look at metadata that shows us if this doctor we're accusing of kind of being absentee actually was in the medical record and was paying attention and what they were doing and when. So that's a much more specific showing that is tailored to the issues in the case. very frequently there are like three main things to think about in tailoring these discovery into the audit trail to the actual issues. Number one, who are the actual providers at issue, right? So a patient who's hospitalized for 2, 3, 4 weeks is going to get touched by, I don't know, 10 to 100 people somehow, one way or another. There's going to be access events by dozens upon dozens of people, and most of them are totally irrelevant to a claim of malpractice. Cut those ones out. Focus on the actual providers at issue. Time period becomes another obvious way to limit the scope of these. Not 20 years of treatment, but the actual day of the negligence or the week of, whatever makes sense under the circumstances. And then finally, in medical litigation in particular, expert disclosures really set the outer bounds, at least in my view, of what becomes relevant, because that is the theory that the plaintiff is tied to. And my view is always that once a plaintiff has served an expert disclosure, that's the definition of what's relevant in the case. And if they can't tie a request for audit data to what their expert is saying, it's just a fishing expedition that's untethered from the facts and the theories, and it shouldn't be allowed.
Can I ask a question / interject? I've dealt with several of these requests, and the ask I often get is, well, I don't know what I don't know. How am I going to tell you if this is relevant if I haven't seen it? It goes to the completion of the medical record, and on the theory of completion, I'm entitled to see if any changes were made, when the doctor accessed it. I could be relevant, but I don't know until I look at it.
Yep.
What's your rejoinder to that?
So that is just an admission that you don't know what you're asking for and you're on a fishing expedition. That's what that means. Like, you have to have enough to go on to bring a case, at least in Minnesota, to say Dr. Jones was negligent in the following ways. And that's at least a foothold to say, okay, I need to know what Dr. Jones was looking at and when. Or you can tie it maybe to particular events in the case. There can be ways to explain relevance, but if it's just, I don't know what I don't know, the answer is then you will continue to not know what you don't know because you can't explain why it's relevant.
You got to have at least a feather.
You got to have a feather. And you've anticipated my next slide. The other point, and again, practical one, this doesn't often carry a lot of weight, when I'm just telling a plaintiff's lawyer this, but like, by the way, this isn't going to tell you anything because it's meaningless, but like, they never believe that until they see it. And they're like, why doesn't this explain anything? I'm like, well, I told you it's not going to explain anything, but so it goes. Second issue. So I'll touch on this briefly. Coming back to patient statutory rights, this is a case in Montana, actually, that, coming back to what I said about the Minnesota Health Records Act, this is a case in Montana arising under Montana's sort of a cognate statute, where the court actually did conclude that the broad language of that statute gave the patient the right to get the audit trail as part of their medical record. And the court went through a whole federal preemption analysis and basically said the Montana law is, quote unquote, more stringent in the sense that it gives patients greater access rights. And so patient gets it. That's not the case in Minnesota, in my view. Apparently that's what was decided in Montana. But I note it because it's of interest. Go ahead.
Far for me to suggest a court was wrong about one thing. But it's interesting because the audit trail doesn't exist. It's not a thing that exists within a patient's medical records. I mean, everything else, when we looked at like the Minnesota rights and what you're entitled to, those all exist.
Yeah.
Those are about you. This is a report that is generated and created. It doesn't exist within your record. So it's kind of like that.
Yeah.
It reminds me of a question that a plaintiff's attorney would pose in a deposition. Like, well, half the premise of that question is wrong. So the answer is going to be wonky. It's interesting to me.
Yeah, I agree. I don't have a good, I didn't spend the time to like really try to, show why this decision was wrong. If it is, I will tell you, as I look at these cases, what I see, the vibes I pick up are that the courts are pretty heavily influenced by their sense of the case, in the sense of like, is the defendant hiding something, or are they really focused on patient rights? And some judges are just really amped up about patient rights to healthcare information. It's a big theme in our culture. And I tend to agree. And some courts share the view you express, which is like, this is metadata. It's not a normal part of the medical record. And they think about it in that way. And others are persuaded by this idea that the feds say you have to have this, ergo everybody does, and you should just turn it over. And it's hard to get a foothold into sort of saying who's right and who's wrong, because it's almost like the fundamental premise that they come to it with seems to drive some of the outcomes. Here, the statute, the language is pretty broad, and I guess that's just Montana's statute. But I think a court could easily come to the opposite conclusion based on practical points that you point out, that like, look, this is really different from the medical record. And it's a privacy device, as I said, it's not primarily supposed to be about patient care. It's basically so we can go and yell at people after the fact if they weren't supposed to be in the record, All right, coming back to this is one more sort of issue that Alan alluded to, or is raised by what Alan alluded to, which is discovery on discovery. This becomes kind of a separate basis, although sometimes interrelated, upon which a party can ask for this. Basic principles, and again, this is like sort of ESI Discovery 101. Generally, courts don't allow parties to get discovery on discovery, if you will, unless they have some showing that there was incompleteness in what was already given, or if something was altered. And so we do have a couple cases, I won't dwell on them, where the courts basically, there's at least enough showing that somebody altered a medical record, and the courts are going to allow the audit log in that case. This second one, I would emphasize, that underlining is not mine. That was in the decision. This one where the doctor who was at issue admitted to going in after the fact, after the patient died, and making a new entry in the medical record. That's going to lead a court to think you should probably get an audit log. On the flip side, to Alan's question, plaintiff's lawyers will be like, well, I don't know, maybe somebody altered it. Just guessing at that or speculating shouldn't be enough, but here you have a clear showing of it. Undue burden, I'll just very briefly say, we routinely object on the grounds of undue burden. Just a reminder that if that's an objection that you want to stand on, you're going to have to show the receipts. And that's going to mean a declaration and a real factual showing that it's hard to generate this much data or deal with it. And courts they tend to be skeptical of that. I think that relevance and proportionality and these other issues are better arguments against discovery. Undue burden plays a role, but just remember, you won't get away with a conclusory assertion. I'm running over here, so I'm going to be quick on this last one. I'm coming around to this point of asymmetries and trying to tie together the things that I've offered here. What I've experienced over the course of my career doing these cases is a tremendous asymmetry in discovery. We being the defense side, we being healthcare institutions, we're the ones with a lot of information, and therefore we are the ones who are vulnerable to getting beat up on in discovery. Lots of demands for information, lots of opportunities to make mistakes or have problems arise that then, as most of us have experienced, are blown up into some allegation of nefarious wrongdoing and so on. That's kind of rotten on the defense side, because you basically just take punches for like 6 months and you deal with issues. And I think, and I submit and I suggest that if the better that we do on our side of things to get our ducks in a row, if you will, up front on electronic discovery, the more we can start to punch back and right some of these asymmetries. As often, the most concrete example I'll give you is that in any major commercial litigation now in federal court, most principally, it is absolutely expected that the lawyers will discuss in detail ways that they're going to deal with electronic discovery as the case progresses. And that's like part of the Rule 26 report. Virtually never happens in med mal cases. Often I'm glad about that, because I don't really know what we might find on our side, and we're worried about creating those issues or inviting that scrutiny. And I would love to not be in that position, because actually, as the world is evolving, it used to be that the traditional perspective was plaintiffs are just individual people. They don't have any electronic data. Guess what? We all have massive amounts of electronic data. I just joined like a couple months ago the world of people with Fitbits. I am a walking database of my own physiologic data. And so I gave you one interesting thing that caught my eye in preparing this, which is cases permitting discovery of plaintiffs, med mal plaintiffs, or personal injury plaintiffs' personal health fitness data. When somebody is claiming that they can no longer walk and their Fitbit shows them walking 5 miles a day, that's discoverable. And there are some cases permitting that. And that's really interesting to me. And I don't think there's a lot more to say about it at this moment other than think about it. Start serving those discovery requests where it is appropriate, where it's relevant. And I think thinking about both sides of these things, you can start to remedy some of those asymmetries. Let's turn it to Vanessa for some discussion and data, speaking of data, on jury verdicts And then if there's any time for a question or two at the end, we'll take it.
All right, the juicy stuff. I'm going to be talking about jury verdicts. And this topic came up because in the last couple of years, it's felt like every legal circle I've been in, there's been discussion of nuclear jury verdicts or runaway jury verdicts. And of course, defendants have always been concerned about jury verdicts and particularly bad jury verdicts. Some of the recent cases have really, I think, escalated that talk. And there's discussion of, have juries changed? Are they concerned with things that they weren't concerned with in the past? Are they angrier? Are they trying to make a point? And for our specific context, like, is there a shift in how juries feel about medical professionals? And I'm going to highlight just a few recent cases that have prompted this discussion. One out of Iowa, Crumpart v. Mercy Hospital, involved a $97.4 million verdict in 2022. That case was a labor and delivery case, which I think is important in a little bit. Another case, this one out of Georgia, the estate of Nicholas Caruso versus Metro Atlanta Recovery Residences, Inc., involved a jury verdict of $77 million. That was a wrongful death case that included $1 million in punitive damages and potentially some backdating of records. So relevant to what Andrew was just talking about. Also out of Georgia in 2002, Buffalo v. Womack was a $75 million verdict. And this was a failure to diagnose case where a patient suffered a stroke that turned into locked-in syndrome, which is essentially where an individual suffers from total paralysis, but they're still mentally fully conscious. Florida has always been a well-known jurisdiction for big verdicts, but there have been a couple of them recently that are big even by Florida standards, and that's Crohan v. University of Community Hospital, Inc., where a jury awarded $68.8 million in a verdict for a case of mismanaged sodium levels that led to severe brain damage. Out of New York, there was a $121 million verdict in Lee v. Westchester County Healthcare Corp. And the facts of this case seemed particularly problematic. Physicians not trained to read CT scans determined a patient had not suffered a stroke. That determination was later, I don't know if overruled is the right word, but determined to be incorrect when the radiologist arrived 3 hours later. And the allegation was there was a delay in surgery and improper monitoring, and that led to permanent brain damage for the patient. Also out of Florida is Kowalski v. Johns Hopkins All Children's Hospital. This one, I think, is the largest I've seen. It was $211 million. This was a very complicated case that wasn't just medical malpractice claims. It also involved mandatory child abuse reporting requirements. And so it included claims of false imprisonment, which may have led to the particularly astronomical verdict. And then here in Minnesota, in 2022, we had Thapa v. St. Cloud Orthopedic, where there was a $111 million verdict. That one involved compartment syndrome. So massive verdicts. I want to preface to say that these huge verdicts rarely stand, at least in full, following motion practice and appeals. In Minnesota, for example, the Thapa case was remitted to $11 million by the district court. Plaintiff rejected that in favor of a new trial. And it's my understanding the case settled for an undisclosed amount recently. So despite the huge numbers in these cases, that doesn't necessarily mean that is the final number. But the headlines certainly suggest, are jury verdicts going up? And I was kind of tired of the war stories from attorneys sitting together saying, well, back in my day, it wasn't like this. And we decided let's look at some actual data and see what we can find. Before I dig in and show you some of that data, I want to explain what our process was. So we researched medical malpractice jury verdicts in Minnesota from 2018 through 2023. We were relying on publicly available data from jury verdict reports and then doing additional searches for cases on Lexis and Westlaw. Now, our data is only looking at jury verdict outcomes. We don't have access to any settlement information, and what I'm about to show you doesn't take into account those reductions that we often see by courts, either at the district court level or on appeal. Because what we wanted to look at is what are juries doing. We also counted any verdict as a plaintiff verdict if at least one defendant was found by the jury to have been negligent. So I know there's at least one case in there where some of the defendants were found not to be negligent, but another one was, so that's been included as a plaintiff win. All right, let's look at some data. So starting out, this slide is showing negligence findings in cases, in medical malpractice cases in Minnesota from 2018 to 2023. It was important to us to include data pre-pandemic as well as post-pandemic, because a lot of the discussion has been life change. Well, we all agree, life changed in the pandemic. So it was, have plaintiff jury verdicts in Minnesota changed post-pandemic as well. So in both 2018 and 2019, as you can see on the left side of the slide, there were 8 medical malpractice jury verdicts. 7 of them were defense verdicts and 1 was a plaintiff verdict in each of those years. So that's a pretty good outcome. In total, that represents 88% of cases were defense verdicts in both 2018 and 2019. As we move forward in 2020, we all remember what happened then. So the number of cases steeply drops off to just 1 medical malpractice case that actually Andrew and I tried in January of 2020, just sneaking in pre-pandemic. But we get the 1 defense verdict win of the year. So 2020 was 100% defense verdict year. Of course, that's not a very good representative sample. In 2024, as things opened up a little bit more, there were 4 cases. They all were defense cases, which is pretty interesting. Again, we don't have any insight into how many cases settled. It would be interesting to know if perhaps in this time frame, some of the not as strong cases maybe decided to settle out rather than waiting for the courts to reopen. That's pure conjecture on my part, but it would be interesting given that even with 4 cases, they were all defense verdicts. Turning to 2022, I think there's a huge, it's more than triple the number of medical malpractice cases that we saw in 2018 and 2019. And I think that's representing a huge backlog of cases finally making it into the court. It was safe to have jury trials. So we are seeing those. And while it is still overwhelmingly in favor of defense, it was 18 out of the 23 cases came out as defense verdicts. There were 5 cases that were plaintiffs favor blue. Percentage-wise, so we saw in 2018, 2019, it was an 88% defense verdict. In 2020, it dropped down to 78%. So it is a significant percentage drop. Although I will note one of the cases that came out as a plaintiff's verdict was declared a mistrial. We didn't see if that case actually ever was retried. But if you take that one out, the defense percentage goes up slightly. 2023, interestingly, the number of cases dropped back down significantly to just 4, and it was 100% defense verdict. As we'll talk about in a minute, DAPA was a 2022 case with a very large verdict. Did some cases settle out after seeing that big verdict? Possibly, don't know. We don't have any data on that. But it seems unusual that despite the big backlog, that likely happened during the pandemic, there were only 4 jury trials in 2023. So let's talk about verdict amounts, which is, I think, what people might be most interested to see. This plots every trial we were able to find from 2018 to end of 2023, and it looks
Minnesota, right?
In Minnesota, correct? In Minnesota, not nationwide. No, I don't think we could fit them all on in one. All the data is specific to Minnesota. You can see there's one big spike in 2022. That is the THAPA matter. It really does look like an outlier, and it actually makes it really hard to kind of read the rest of the data. So we decided, let's take a look at what does that look like when we take THAPA out. And that kind of provides a better understanding of what a more typical jury verdict in Minnesota will look like from 2018 through 2023. Of course, you still have the majority of the verdicts came out at 0 damages because they were defense verdicts. But the majority of them are 3 out of the 5 cases, excluding THAPA, are below $2 million. The next one is about 3.5. And then there was one case in 2018 that was close to 9 million. And I think it's worth noting that there were some factual differences between these types of cases. Now, the 2018 case involved, it was a labor and delivery case. And sort of a theme I noticed when looking at these cases, anytime you're dealing with children, labor and delivery, obstetrics, childcare, those clearly are really emotionally charged cases and have the possibility of being higher. We also saw a 2022 case that involved labor and delivery that was a defense verdict. So that's not to say they can't be won, they should all be settled, or that the care provided wasn't appropriate. I just think that is a potentially hot button issue. The 2019 case involved nephrology care that resulted in total loss of vision for the plaintiff. And that may be part of the reason that verdict was a little higher. And the remaining 3 were all nursing home cases, or 4 actually were nursing home cases. So we also thought it'd be helpful to look at it, by damage type. What's really driving the bulk of the verdicts? And again, here we have all of the cases, with THAPA being the big one in the middle, and future non-economic damages, certainly of any of the larger verdicts, are definitely the driving damage type. I don't think that's particularly surprising to anybody. Those are the hardest damages to actually have sort of any sort of mathematical calculation for how you get to a certain damage amount. But again, THAPA is such an outlier in its amount that it's kind of hard to see what the other cases look like. So we took a look at the Minnesota verdicts excluding THAPA. It's a little bit easier to read. I think still future non-economic damages are a driving force in some of them. That 2018 case, which involved an infant, we also see some future income loss was a good portion of that jury verdict, which, given the particular facts of that case, an infant had, that person would have had their whole life in front of them. You're going to have some economic damages. Whereas the 2022 cases, when you exclude THAPA, those are all nursing home cases where those individuals are already out of the workforce. You're not going to have any income damages there. So I think this brings me to, what can we take from all this data? Despite the massive headlines from cases across the country, I think looking at the Minnesota data overall, the landscape looks pretty good. In total, we identified 48 cases. 41 of them are defense verdicts. That's about an 85% defense win, which I think overall is really high. Of course, that means people are bringing good, they're defending good cases. The care was good. This isn't to suggest if you have a bad case that you shouldn't settle it, because defendants win a lot in Minnesota. Of the plaintiff's verdicts post-pandemic, all but one of them are pretty reasonable. Not to say you ever want a jury verdict, but they're not, they don't shock the conscience when you see them. Like when you look at THAPA here and you've got the other 2020 cases like barely are a line in comparison. But I think, despite the overall good prospect, I did see some common themes throughout many of the really large verdict cases. Watch for the tough cases with bad facts. As I mentioned, labor and delivery and cases involving children appear to be, which I think people knew this, without looking at any data. Those are sensitive cases that are potentially hot button cases that could result in high verdicts. Bad faith and misconduct, be aware of those cases. The estate of Nichols, Caruso in Georgia, the allegation that appeared to win the day was defendants created and backdated records in the days after Mr. Caruso's death to make them look as if the facility had written them when he was a patient at the facility. That was a $77 million verdict. If the jury believes that's what really happened, it's not as hard to see why not only did they award punitive damages, but a large amount of money. Severe brain damage cases also appear to be a really tough one. 3 of the cases I identified involved brain damage, and I think one was the locked-in syndrome where the patient's conscious but can't move, and the others were they had permanent long-term disabilities as a result of the brain damage. So keep an eye out for cases like that. That could potentially, even if it's a defensible case, that's likely going to be a hot button issue that you want to get in front of and have your story really well developed. And the last theme is sometimes you don't know. THAPA, I think, is an example. I don't think anybody understands why that one was as high as it was. It doesn't fit any of the patterns of any of the other cases. And sometimes I guess you roll the dice and they're not good. But moral of the story is overall it looks good. Just keep doing your diligence on your cases, settle out the bad ones. And if you have a good case, at least in Minnesota, it's worth taking it to a jury.
Yeah, I would say the takeaway here for healthcare systems in Minnesota at least is keep calm and carry on, right? The oh my God, you'd better settle this case because juries are handing down massive verdicts these days is kind of made up. Actually, the data that Vanessa has just reviewed show us that actually, of course, there are occasional lightning strikes, but it's not a sustained trend, it would seem, at least not here. And, stay the course, I think would be my suggestion. Obviously, you got to make a decision on each case as it comes, but don't get freaked out by these random lightning strikes. So we're a little over time. If there's questions, come to us after, perhaps. Thank you to everyone on the web and everyone in house. And we'll see you out there. Thanks.